Hello and welcome to episode 90 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh Dehaas, counsel with the Canadian Constitution Foundation.
And I'm Christine Van Geyn, the CCF's litigation director. Joanna is away today. And in today's episode, I'm going to be telling you about a Saskatchewan student facing discipline for his very vanilla comments about DEI.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to tell you about a new lawsuit challenging a so-called graphic images bylaw in London, Ontario, and why I think it matters for freedom of speech. So, Christine, if you have lived in any big city, you've probably seen some of the anti-abortion flyers in your mailbox, or people holding those signs on street corners that show fetuses at various stages of development.
Yeah, I
And
actually saw a big truck driving around 2 weeks ago with those images on it.
yeah, that's news to me. I didn't know there were trucks doing it, but I think if you see these images, you have an emotional reaction, and that's frankly the point. The anti-abortion activists who put these images out there in the world want people to see fetuses and cause an emotional reaction because, in their view, that will make people think about whether abortion is moral or not. And obviously, the pro-abortion activists on the other side of this issue don't like the tactic. They want it shut down. In their view, the anti-abortion people have no right to upset or disturb women who may have had an abortion or feel vulnerable or targeted by these images. So the pro-abortion people have organized a campaign to outlaw this practice of standing with signs showing fetuses and putting fetuses in mailboxes without warnings on the outside of the envelopes that say contains graphic images that may be offensive or disturbing. And so far, these anti-abortion activists have been really successful in getting municipalities to pass laws to that effect. Although they haven't seen as much success at the provincial level. For example, there was an NDP private members bill that aimed to outlaw these signs nationwide, and it didn't get very far. As we documented last month in our most censorious bylaws report, which listeners should go to our website, theccf.ca, and download if they haven't already, these so-called graphic images bylaws are in place in many, many communities. They're in place in Airdrie, Alberta, Burlington, Ontario, Calgary, New Westminster, BC, Waterloo, Ontario, and there was one in place in St. Catharines, Ontario, but they rescinded theirs after the threat of a legal challenge, which isn't surprising because when I first heard about these bylaws, my initial thoughts were they can't possibly be constitutional. But London, Ontario, which was the first to pass one, still has theirs in place. And now a group called ARPA, which is the Association for Reformed Political Action, is taking London to court, arguing that the purpose of the bylaw is to restrict pro-life speech. So I'll put my cards on the table here. I really don't think there's any question that this particular bylaw is an unconstitutional restriction on free speech. To me, it's a pretty clear-cut example of a content-based restriction. And that nullifies the very purpose of freedom of expression, which is to allow individuals to pursue self-actualization, self-government, and truth-seeking without censorship from the government. It's not, a reasonable time, place, or manner restriction. But I also have a lot of sympathy for people who encounter these images and find them upsetting because they can be upsetting to see. And I wonder if there might be some solution to make the bylaw constitutionally compliant. I'm not sure, but I do think that this particular bylaw is unconstitutional. And I don't really think this is a left-right issue as much as it might first seem. It just happens to be that the left is organized here in this case to shut down free speech. And for those who are on the left who think this is a good idea, I say, be careful what you wish for. Because, for example, if you live in a small town where there are a lot of people who find the LGBT pride flag offensive, if municipalities can ban images of fetuses, they can ban images of pride flags too. And in a free society, they shouldn't be allowed to do that. And I know people will say, well, pride flags are objectively less graphic or upsetting, but the reality is that is subjective, which is why in free societies, individuals, not the state, get to decide what people can and can't say. And, enduring some emotional upset from seeing speech or hearing speech that we don't want to hear is the price we pay in a free society for freedom of speech. And the better way to tackle this than the government stepping in and censoring is for people to use social opprobrium. If people find these images really upsetting, they don't want to see them, they should pressure their fellow Canadians to not show these in public or to put their own warnings on the envelopes if that's the solution. So I haven't seen ARPA's statement of claim, but they do have a news release that points out a number of things, including that this so-called graphic images bylaw bans any image of a fetus, which would include, for example, an ultrasound photo of a healthy baby in the womb. And it's hard to argue that that's graphic. So in that sense, it's clearly overbroad. They also point out that the bylaw doesn't apply to other images, graphic or otherwise, that you could describe as graphic and say are upsetting. It really just targets this one form of political speech. So it couldn't be more clear what the city is doing. They're trying to shut down a single type of political speech. And ARPA also points out that the law requires anti-abortion activists to literally write on their envelopes that fetuses are graphic when they don't believe that to be the case. They believe that fetuses are not graphic. One of the people in the news release says, pictures of an ultrasound of a fetus, for example, can be beautiful. People put them on their fridge. So I think this does violate freedom of expression, and it'll be interesting to see what the court does, because, us saying that we believe something is clearly unconstitutional and what the court will do are two different things, Christine, as you well know. I know you've read a little bit about these bylaws too. Do you have any sense of where you think the court might go with this?
I am so sometimes when I think about these things, I just get really depressed because it seems like our courts are just outcome driven a lot of the time, unfortunately. And the reality is that this form of protest is really unpopular. People really don't like it. And as a result, I worry that a court would just, they're not supposed to do this, but they would come to a conclusion based on that alone, on the fact that these are distasteful. I think your point about this not actually being a right-left issue is a really important one. I don't think the pride flag is the right analogy. I think a better analogy would be because a pride flag's not graphic in any way. And I do think that these images of fetuses, like the one I saw in the truck, I mean, some of them are really graphic. They're very upsetting pictures. So a better
That's entirely
analogy,
subjective,
it
Christine.
is
That's the issue. Like,
to
it's
me,
entirely
but
subjective.
the reality is it's a dismembered fetus. Some of these are images of dismembered fetuses. So I think a better analogy is is to war imagery. So anti-war protesters will sometimes show graphic images of war and use those images to advocate for an end to war. And those images are also very upsetting. Those images could also be described as graphic in the exact same way. So I think it's a really well made point to people on the other side of the political spectrum. Be careful what you wish for, because if you believe that that is an effective form of advocacy, if you support a ban on these the graphic image abortion law, if you support that, it could apply to your same type of advocacy. I want to turn now to my news headline, and my news headline is actually about a friend of the podcast and some serious drama that he is dealing with. It's about our very own Tim Hagstrom, who is the director of the Runnymede Society. And he has been in the media recently, actually dating back to 2022, but he's in the media again this week over his fight with his former law school, the University of Saskatchewan. And the basis of that fight, as I said, dates back to 2022 when Tim was a student there. And he wrote an open letter to his fellow students about various DEI, a dispute that was happening at the university over DEI and his view about open discourse and its importance in a university. So let me get into it. First, I want to say I want to be very clear that I really support Tim. But we at the CCF are not actually involved in his case. He's represented by another really excellent organization that deals specifically with student issues, and it's called the Freedoms Advocate. Now, you're probably wondering what horrible things did Tim write that got him into hot water with his university? Or maybe you have actually been paying attention to what's been happening at universities, so you already know that the university has just freaked out over nothing. But let me tell you about the backdrop for this whole thing and what the letter said, and then I'll tell you what I think. So, Tim's letter related to a debate that had bubbled up around a number of issues, but I think the instigating issue was an exam accommodation policy at the university. So the law school had a policy that gave some Indigenous students extra time on exams. And it seems from what I understand that this policy has actually been around since the 1990s, specifically for those students who were admitted to the university through an Indigenous specific pathway and attended an academic support program. But in addition to that sort of being the instigating issue of the debate, there were a lot of concerns in the student body at the University of Saskatchewan related to broader DEI initiatives. So, for example, in 2018, the school began mandating a full year Indigenous course for first year law students that included things like sharing circles, personal reflection assignments, and covered colonialism, reconciliation, and Indigenous legal traditions. In 2020, the university president committed himself to, quote, dismantling of institutional structures, policies, and processes that contribute to inequalities faced by marginalized groups. In 2021, the university signed a memorandum of understanding with the student union committing to delivering, quote, anti-oppression and anti-racism training to staff. This initiative was actually led by an anti-racist scholar who has a very particular progressive worldview. And the training materials teach things like hierarchical understanding of race, specifically that white people have better access to education and success. The training materials characterize meritocracy as a feature of, quote, settler mindsets. And they state that internalized colonialism causes oppressed people to commit sexual assault. The materials instruct readers to refute colonialism, to assist in making Canada the friendly, open and welcoming country it espouses to be. And they say that anti-oppressive education ought to be uncomfortable as white students begin to unlearn what they have been taught through their previous learning experiences. So those are some of the things included in the training materials. Then in 2021, the university released an Indigenous strategy that planned for institution-wise decolonial change. And in 2022, the law school instituted mandatory anti-racism training for first-year law students. So against this backdrop, some students began objecting to this policy dating back, I guess, to the 90s of extra time in exams for some Indigenous students. And as these objections to the exam policy grew, the Law Students Association president held a meeting. And at the meeting, he described the concern of the students who were objecting. They said that there's a high number of students who get extra time on exams, and the University of Saskatchewan numbers are higher than most other colleges. And this is turning into an issue of equity. So him, mildly questioning or even articulating the concerns of others who question the exam accommodation policy made other people freak out. They were completely outraged that the exam accommodation policy would be questioned. And the whole university got caught up in this debate. There was a lot of conflict at the time. And this is where Tim sort of gets involved. He wrote two letters. First, he wrote a private 7-page letter to the faculty in February. Then he wrote a shorter 3-page letter to his classmates in March. And these are the letters that got Tim into trouble. And when you read them, which I recommend you do, there's an article in the National Post this week that actually links to the text of the letters. His letters are reflective, they're thoughtful, they're nuanced. They, in my opinion, are so uncontroversial it is shocking that something that frankly is kind of milquetoast to me, that it's the subject of discipline. So here are a few things he said. He wrote that disagreements are never going away, but that diverse perspectives are opportunities, not threats, and should be met with courage, not fear. Ooh, like so scary. He wrote about our shared humanity, and he described that perspective. He described the perspectives of others, that of people on both sides of the debate without actually taking a position himself. He said that we are too often fearful of having our opinions challenged and that we should talk to one another, and that for discourse to work, it needs to run in both directions, and that there is actually a lot to learn from people with whom we disagree or who even offend us. I mean, come on. He did not even take a position on the issues, from the training to the mandatory classes to the exam accommodation policy. He just asked for discourse and open-mindedness. So he read the letter aloud, or I don't know if he read it. The letter was read aloud at a meeting, a student meeting. And at the same meeting, he also questioned whether the Law Students Association should add a requirement to all open meetings that they begin with a land acknowledgement. Ultimately, this was voted in favor of as well. But the fact that he read this letter and he said, maybe we should think about the land acknowledgement issue, all of that led his classmates, some of them, to completely freak out, and the university in turn to freak out. So his letter was sent in March. This all happened in March. In April, a fellow student lodged a non-academic misconduct complaint against him, alleging he had breached the university's harassment policy through his frightening letter and his resistance to the land acknowledgement, or not even resistance, just raising the question of maybe we should think about this. The complaint against him alleged that he had made numerous attempts to, quote, spread hate throughout the college, and that he had created an unsafe atmosphere for Indigenous students. But instead of being dismissed out of hand as being ridiculous, this complaint was taken seriously by the school. There was a lot of back and forth about mediating a conversation between Tim and the complainant, but instead of agreeing, the accuser added more people to the complaint. And then one of the accusers even contacted Tim's employer, the law firm that he was supposed to begin articling with. Now, there was a lot of back and forth about how things would be resolved. Tim ultimately filed his own complaint about the student who had contacted his employer. And, there was back and forth about this mediated conversation. Ultimately, the university said he could have a mediated conversation with his accusers, but only if he acknowledged the, quote, harm he had caused from his letter. Tim refused to do that, so a formal mediation was directed. Now, meanwhile, there was a formal misconduct hearing, and that took place in May and August of 2023, so more than a year after Tim had graduated. And he was found guilty by the University Senate of this discretionary harassment and breach of the student code of conduct. Tim was ordered to apologize and express regret for his thoughtful letter. Tim attempted to appeal, but his appeal was denied in the summer of 2024, so now 2 years after graduating. And now Tim is trying to rectify this whole thing in court. He has brought an application for judicial review and for relief under the charter. This is a charter-protected freedom of expression issue. And his case is now in the early stages of that process. Now, there are a lot more details. I kind of tried to give the high-level picture. I recommend reading the National Post article. It gives a really good description. It also links to Tim's open letter, which is a really thoughtful and nicely drafted letter. I think we actually all can learn a lot from reading that letter. And it just blows my mind that something so reflective is considered harassment by the university. I think we should all mourn for the loss of discourse at universities and the fact that someone calling for open-mindedness and conversation and trying to learn from one another is now subject to academic discipline, sorry, non-academic misconduct discipline. And I think that this is going to create a chill on universities that will cause problems for anyone who is interested in exploring ideas, which is the very purpose of universities. So, Josh, did you know all of the details in Tim's case? I mean, I was aware when Tim joined Runnymede that this was happening. I had read his letter. I thought his letter was amazing, but I actually didn't know that someone had contacted his law firm to try and compromise his employment. That is just awful.
Yeah, I didn't know that detail, but I should say it doesn't surprise me. There's this, well, in my own law school, in the very first month, I believe, the dean called us all to a special assembly where they had a journalism professor from TMU, formerly Ryerson, basically come to give a lecture on how you shouldn't say anything controversial, by which she meant anything non-woke or progressive, on social media, or you won't get a job. That's essentially what she said. And she said, here are a bunch of Twitter accounts that you should follow and that you can retweet. And Josh Wasili Harrington, one of the most extreme radical leftists, horrible person in my opinion, was on the list. And basically the implication was don't retweet anything that's not left progressive or you won't get a Bay Street job. And I posted a complaint about this on our Facebook group at Osgood, my university, just saying, hey, this is ridiculous. You should be able to have opinions in a law school and you should be able to express yourself publicly on social media. And they basically like ended the Facebook group. Like they created a new policy that you weren't allowed to have opinions on the Facebook group as a result of me posting that. Like that's how bad things are. And people at law school, they're scared to say anything in their classes because of this requirement that you only have progressive views or that you only express progressive views publicly. And I mean, that's one of the purposes of Runnymede, which Tim is now the national director of, is to allow people to have those conversations, not necessarily take the left side, the right side, the libertarian side, the progressive side, but just be able to have those conversations because lawyers need to be able to not only defend their side of the argument, but also make the best case for the opposite side, whether it's, you know, something like a graphic images bylaw where Christine, for example, had a better analogy than I did. Now that I think about it, you need to be able to have those conversations, right? And this is still going on. I had dinner the other night with a friend from law school who was involved in Runnymede Society, and he just had an interview a few years after graduating from law school where they brought up a Facebook post that he made several years ago and then said, why would we give you the job if you have this particular opinion on gender identity? And it was like, it's still happening. So good for Tim. The only way to get through this and to bring back diversity of thought on campuses is for people to speak up and to face the punishment and to push back using the legal tools they have. I mean, Tim is 100% in the right here, and I wish him well. And I think we need some new law schools in the future if this doesn't change. Okay, so that's all I'll say about that. Let's take a break, and then when we come back, Christine, you can give us your bad legal take.
Okay, so my bad legal take this week is not actually a legal take. It's more like a bad life take that was me, my own bad life. So I don't usually talk about my personal life or my non-CCF life on the podcast that often or generally in public that often, but I just got back from the Middle East and it was really dramatic, guys. Like this was not a good situation that I just managed to barely avoid. So I had been scheduled to take part in a mission to Israel with a group of people from sort of across the political spectrum where we were going to learn about Israel. We were going to learn about the culture, about the current conflict between Hamas and Israel. We were going to meet with some politicians. We were going to meet with Palestinian activists. And I think that there is a lot to learn from people who are directly affected by the conflict in Israel. I have my own thoughts. Obviously, I've expressed those about the war on this podcast a few times, but I think my opinion is informed from afar. And I think going to meet the people who are directly living through everything that is going on will better inform my own opinion and would be very meaningful. It's also a really spiritually and historically important part of the world. And a lot of the um, politics of today are all about what's going on in Israel. So I was scheduled to arrive in Israel the morning of the 13th, the morning of June 13th, to then go arrive in Tel Aviv, travel to Jerusalem, and start this mission. And I decided my direct flight had been canceled. My flight to from Toronto to Tel Aviv had been canceled after the Houthis sent that missile that landed in the perimeter of Ben Gurion Airport in Tel Aviv. I probably should have taken that as a sign that this was, the conflict is still a little too close for comfort for a trip to Israel. But these missiles are part of daily life in Israel, and I figured, this is something, if I'm going to go there, this is part of the risk and part of what I wanted to learn about. How big a risk is this? Because a lot of airlines did continue to fly to Tel Aviv, including Etihad, which is the Abu Dhabi airline that I ended up booking my trip through. So I flew on the 10th. I landed on the 11th in Abu Dhabi. I spent 2 days in Abu Dhabi, and on the morning of the 13th, I woke up at 5:30, packed the rest of my belongings, and got in a cab to the airport to arrive for 6:30. On the way to the airport, I looked at my phone, and it turned out that a war had just started between Israel and Iran. And I was about 2 hours from being in Tel Aviv. So, or being on a plane on my way to Tel Aviv. So I missed being a part of that conflict by 2 hours. If I had if I had planned to arrive earlier, which was my original plan through Air Canada, I would have been stuck in Tel Aviv in a bomb shelter. So I don't know if I don't know if this is a bad take. I don't know what part of this is bad. Everyone in my life is telling me that I made a huge mistake in trying to go there during this time. Uh, I think I still would like to go to see Israel one day, but this is not a good time. When I was in the airport and my flight was being quote delayed, I was at the guest services desk, and there was a family from Tel Aviv there. And I said to them, "What's your plan?" And they said, "Well, it's just delayed. The flight's just delayed by 3 hours." And I was like, "I don't think it's delayed. The airport in Tel Aviv is closed. I don't think that the plane is going to go there." And they were like, "No, it's just delayed. It's going to still go." And I was like, "I don't care if it does go. I'm not going to Israel right now." And they said, "Why? Why would you not go?" And it's just such a totally different mentality. I had to say, I don't live there. I'm going for fun. And they were like, "Oh, yeah, it would not be a fun time to go right now." Like, understatement. Fortunately, my friends who did arrive in Tel Aviv early or on time, we were supposed to arrive that day. The ones who did arrive are now safely out of the country. They were able to cross a land border into Jordan and are now scheduled flights out of Jordan. But this was a really close call. It sort of gave me a lot of perspective on how fine a line we all live between being in a really safe environment and one where things are in complete chaos. And it made me very reflective on how fortunate we are to live in a country like Canada, where we don't deal with the daily threats that family in the airport, that Tel Aviv family that I spoke to, completely unperturbed, just completely viewed this as I mean, it is definitely worse now, but they viewed this as sort of a normal part of daily life. And I feel so grateful that that is just not a part of the life for me and my family. So, I don't know I just wanted to include this anecdote in the podcast because it was a really big deal for me. And I don't have things that are that dramatic happen that frequently. So I'll give a bad take to myself in deciding to go to a war zone and missing the war by just 2 hours. Josh, what about you?
Well, my bad legal take is a little bit more lighthearted. It goes to protesters who are occupying part of Queen's Park, so the legislature grounds in Toronto, in opposition to the Ford government's Bill 5, who keep asserting that local journalists are not allowed to film them occupying the park because the encampment has a sacred fire. You see, when, white people like me build a fire, it's just a meaningless burning of wood. There's no spiritual element. But if you're a protester, apparently you're allowed to just set up a fire in the middle of the city, and there's something so magical about it that the regular laws do not apply. So what I'm talking about is an exchange captured on video by Kara Masad and her videographer who spend their time going around filming various protests in Ontario. And it's really a fascinating public service that they do because nobody else is going and showing what these protests look like. And I don't think they have any particular agenda, but a lot of protesters really don't like them. In the latest video, a group of protesters involved in this encampment at Queen's Park can be seen surrounding Karama and her videographer and accusing them of harassment. They keep saying this is about the sacred fire. In the latest video, police on bicycles come up and they tell the protesters that, in fact, she is allowed to film. Despite that being obviously true, that you're allowed to film other people in public, I'm actually almost surprised that police didn't find some excuse to arrest them for simply having the wrong politics. This is, after all, the same place where the man who wrote Free John on a plywood box that had been encasing Sir John A. Macdonald for 5 years was charged with mischief and hauled before a court a few weeks ago. Even though those who, vandalize and tear down statues don't usually face any repercussions. But maybe this is a sign that the world is back on its axis because just last week the Ontario legislature finally freed John from his box. And now it's defending the rights of people like Kara Masad and her videographer to film in public. So bad legal take to the protesters. Individuals can film people in public, even if they have sacred fires. Okay, that's the end of the show. We hope you'll rate us, review us, and subscribe if you haven't already. I would encourage you to download our most censorious bylaws report and check out who got our inaugural municipal muzzle medal on our website, theccf.ca. And don't forget to sign up for our Freedom Update newsletter from our colleague Jess. The CCF is a nonpartisan legal charity funded by your donations, so please click that donate button on our website if you can. Thanks for listening.